guys, and welcome back to another video. I have not worn this since my first year of university, so I'm wearing it for an occasion, which is this video, which kind of goes on the same theme of first year at university. And today I'm making a very, very requested video, and that is the top 5 cases you should know, or every law student should know. Loads of you have wanted me to make this video. Loads of you have wanted me to talk about case law, certain cases that I liked. So that's what I'm going to do in today's video. I've picked the top 5 cases covering trusts, EU, tort and criminal law, and also a bit of ethics. And these are the cases that I've kind of come across in my first, I'd say 2 years at university, and they were kind of interesting for me for certain reasons that I will kind of discuss in this video. And hopefully it'll be interesting for people who either want to study law or who have studied these cases and will remember them as I'm talking about them. So the way I'm going to go through each case is I'm going to say what the case is, what the facts were, what the ratio was, i.e. like what the decision was, and then basically the principle in law, and then my thoughts on it, or how I discovered that case, or basically my comments on the case. I'm going to also put timestamps below for each area of law and for also the cases that I'm going to be talking about. So without further ado, I'm going to jump straight into the death of law, which is trust law, and I'm going to be talking about Knight and Knight. Okay, the angle might have changed a little bit because I changed my camera battery. So I've got my glasses on because I'm going to be reading my notes, which are on my laptop for each case. Knight and Knight, which was from 1840. It's a very old case, but this case is like the foundations of trusts law, and it basically establishes what is needed in a trust. So for those of you that don't know or might not study law, a trust is like a document, like a deed, where you can give people property. It's similar to a will, but a trust basically happens without you having to die, and you can set conditions in it to say, oh, I want to give this person property at a certain point in their life, or, you know, if certain things happen, or if you do happen to die, or if they marry, or whatever. You can put sort of clauses in it, so you can only give your property away under certain conditions. So for the facts of Knight and Knight, so Richard Knight, the main geezer that starts us off in this case, in this story, he makes a trust and he passes down all of his estate to his family line and down the male descendants. Then his grandson, Richard Payne Knight, we'll call him Payne for, you know, the sake of avoiding confusion. So Payne, which is Richard's grandson, he then inherits the estate and he then makes a will. So upon his death, that estate then goes to his brother Thomas and his male descendants after that. And he also put this clause in that said if Thomas wasn't alive or he didn't have any male descendants, then it would go down the next descendant of Richard's line, so his granddad's line. So then the brother Thomas dies without making a will, and his only son also dies before him. So then his only child left is Charlotte, but then she gets married. So it seems that there is no one that this property can be left to. However, Thomas's great uncle's son then swoops in and says, hang on, actually, that can't be right. Charlotte can't possibly get this money because the original trust was in favour of the male line. And that's what he tries to argue, because basically he wants to get the money. But then Charlotte does a counterclaim and says, actually, that trust that, you know, he was saying doesn't really exist, and that the property was left to Thomas and therefore will be given to Charlotte down that inheritance line. So then it went to court, and the ratio was basically given by Lord Langdale, and the ratio is basically the ratio decidendi, which is the decision in the case. So he basically said that the original kind of will or trust made by Payne, which was Richard's grandchild, wasn't very certain, and therefore that the property was given to Thomas, solely to Thomas, and therefore it could then be passed down his line, and therefore Charlotte could get it. So that's what was decided in this case, but a very key principle kind of came from this case, which was established by Lord Langdale in his judgment, and it was the principle of the 3 certainties. There are 3 things you need in order to have a valid trust. So you need to have certainty of intention, i.e. you need to be very sure that you want to create a trust. Secondly, you must have certainty of subject matter, which means you need to clearly state in the trust what you will be giving to that person. Thirdly, you have certainty of objects. Now, this is a little bit more complicated because it depends on the type of trust you're creating, but for simplicity's sake, basically it means that you need to say who is going to get what, and if you don't say who is going to get anything in the trust, then it sometimes can't go to anyone, or it will go to a certain person, or it will stay on hold and the trustee will just keep on to it. So in summary, the 3 certainties are: you need to say that you defo want to make a trust, you need to then state what you want to give, and then you need to say who you want to give it to, and all those things will then create a valid trust. So moving on to the second area, tort law. In my first year, this was my favourite area of law. I really enjoyed tort law. I don't know why. I think the cases seem very like personal and real, so it's easy to like relate to it, and it's quite easy to understand it too. The case I want to talk about is Donoghue and Stevenson. Oh, and what a case. This is like the first case you kind of get at law school, I think. I remember it's a very distinctive lecture that I had on this, which we refer to in my cohort as the bondage lecture, purely because my lecturer Philip basically got people up on at the front of the lecture theatre and tied them up to basically represent the connections between people in the case, but all that was going on in everyone's minds, especially afterwards when we were all down the pub, was literally, it was just like a weird bondage lecture. So I think that's how everyone remembers this case at the law school I went to. So yeah, Donoghue and Stevenson, it was done in 1932, so again, an old case. But the facts of the case are this. So Mrs. Donoghue went to a cafe with her friend. The friend bought her a bottle of ginger beer and ice cream. So the ginger beer came in a opaque bottle, so she couldn't see what was in it. She just obviously assumed it was ginger beer. So Mrs. Donoghue poured half of the ginger beer onto her ice cream to make like an ice cream float. So after eating a portion of that ice cream and the ginger beer, she poured the rest of the ginger beer onto her ice cream, and it's at that point she realised that there was a decomposed snail in the bottle that had then fallen onto her ice cream. Mrs. Donoghue stated that she suffered like a personal injury, she had gastroenteritis, and she had basically a stomachache from drinking and eating part of this decomposed snail, and she then wanted to sue the manufacturer for her suffering. So the main issue in this case was that Mrs. Donoghue didn't actually buy the ginger beer herself, it was her friend that bought it. So therefore, she didn't actually create any obligations or any contract with that manufacturer. Normally when you go into a shop and you purchase an item, there's an exchange there, there's then obligations that need to be sort of met, but because she didn't purchase it, the manufacturer didn't necessarily owe her any obligations, so that was sort of what was at dispute in this case. However, in the ratio, Lord Atkin decided in favour of Mrs. Donoghue and said that she could claim against the manufacturer for her personal injury suffered, and this whole case created a new principle within tort law, which was called the neighbourhood principle. So the principle that Lord Atkin established was essentially that, and I'm going to read his direct quote, which was that you must take reasonable care to avoid acts or omissions, an omission is a failure to act, which can reasonably foresee would be likely to injure your neighbour. Then he asks himself, who then in law is my neighbour? To which he answers, it seems to be the persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts or omissions which are called into question. So basically, in summary, he's saying that Mrs. Donoghue was so, directly affected by the act of her friend purchasing that beer, that then she had a close enough link that it would affect her, and then the obligations would transfer to her as well as the friend, which is like the neighbour principle in effect. So that's kind of an interesting case, and it's just a random one. The snail in the bottle case is what people like term it, what people call it, and I think you really do that in first term, first year, so yeah, it's just like a throwback case if you've been to law school like I have. Then next, EU law. EU law is something I absolutely hated when I was at law school, but then when I did it towards the end of my second year for an exam, I actually really kind of quite liked it. I found it was quite easy when you get your head around it. It took me like a year and a half to get my head around it. So one of the key cases in EU law is Factortame. Now there've been multiple different cases of Factortame because it's been going back and forth to the courts for years. But I'm just gonna read out Factortame 2, which is obviously the second case in that saga on Factortame, which is kind of like, I guess, the main one. It's quite a short case, but the actual case is very long, but I've summarised it quite, quickly, and I just think it's kind of an interesting case, especially especially with Brexit and stuff that we're doing now. It's quite interesting. So the facts are quite simple. Essentially, new British legislation came in that said if you want to register a ship in Britain, most of the crew members need to be British. So following that, a group of fishermen from Spain wanted to judicial review this law and say that it was actually in conflict with the EU law that was currently like around. And judicial review is basically a public law mechanism that can be used to challenge decisions made by authorities. That's basically the facts of the case. It's quite short. So there were two elements to the ratio in this case, and this went to the House of Lords, which at the time was like the Supreme Court of England. And they basically said that they were in favour of the fishermen. The fishermen were empowered under EU law to restrict parliamentary legislation in England if it conflicted with EU legislation. It basically established the hierarchy between EU legislation and also UK legislation and which one was superior. And then the sort of second element to the ratio of that case was that it was also found that a member state, i.e. like a country in the European Union, if found liable of like breaching EU law or having a law that conflicts it, could have a financial amount imposed upon them to pay for that liability and for basically having a law that breached EU law. And it also said that people could put in private claims against that member state for any like suffering or liability caused. So in summary, those Spanish fishermen could have like put a private claim in against the UK to say that the law was discriminatory and that it conflicted EU law, and they could have got money in compensation that way. The principle of that case was establishing the hierarchy of law and stating that EU and like European law was higher than UK law. So if we had a law in the UK, the EU could just overrule it, or the EU could put laws in place in England and we wouldn't really have much of a say over it, which was one of the key points of Brexit. I think that case is kind of like an interesting one to know about. And finally, my two criminal law cases. So the first one, this is honestly one of my favourite cases. I love this case. It's Dudley and Stephens, and this was in 1884. So again, it's old. All law is old. Basically, I did this case when I was studying philosophy of law, and we sort of did criminal law within that, and it's quite like an ethical case, and it's just really interesting, I think. Like, it has a big ethical dilemma in it, and a lot of questions can be posed, which I will sort of mention at the end of this case. And it's just interesting. It's just a bit more interesting for me than the typical like general murder stuff. So the facts, there's quite a few, so I'm just going to read them out. The two defendants were shipwrecked in a storm. They were forced to abandon the ship and were stranded in a small boat with two others, including a young cabin boy. They had been stranded for 18 days. The food ran out on day 11 and they had no water for the last 5 days. So Dudley and Stephens, which are the two defendants, agreed to draw lots to see which one of them would be killed so the others could survive. The third person in the boat, so not the cabin boy and not Dudley and Stephens, basically objected to having his straw being, his lot being pulled, and he didn't want any part in it. So they all then, as a three, decided that, well, the cabin boy is really weak, he's got no family, he's gonna die anyway, we'll just kill him. And that's what they did. So Dudley and Stephens slit the cabin boy's throat, and because the cabin boy was too ill at the time, he couldn't put up any fight, and then basically they drank his blood and ate his meat for the remainder of the time that they were stranded for. 4 days later they were rescued, and when they came back to England they were put on trial for murder. So the ratio of this case was that Dudley and Stephens, thankfully, were convicted of murder. The defending barrister tried to use the defence of necessity, which basically justifies an unlawful act if the situation requires it, but the court was having none of it, to basically say that it was not a necessity to kill somebody in those circumstances. And they kind of argued in the case that the reasons for this were because at the time Dudley and Stephens didn't know if they were going to be rescued, they didn't know how long it would take, and they kind of acted on the assumption that they might never be rescued, and therefore even if you did kill the cabin boy, that it wouldn't have enabled them to survive for like indefinitely, so therefore it's not needed for them to kill him because they would have just died anyway. And equally, if they did get rescued in 4 days' time, they could have potentially survived those 4 days without killing him. So kind of that was the argument that was used in court, and in the end the Dudley and Stephens were sentenced to death, because obviously that's what they did in the 1800s, but then they were granted a pardon by the Crown Court, basically to acknowledge that they went through this harrowing experience of being lost at sea, and then they just served 6 months in prison instead. So there's a really interesting principle really in this case, which does evolve around the necessity principle that I've just sort of mentioned, which Lord Coleridge does sort of elucidate in the case. It's really interesting to read actually, so I would recommend reading it. And it kind of poses the ethical dilemma of, is killing in a situation, whether it's life or death, is that necessary? Is it a necessity to kill somebody if you are stranded out there? Do you think it's a justified killing? You know, he was ill anyway, he would have just died anyway, it wouldn't have made a difference because he was so ill, the cabin boy was it justified that they killed him to survive? Like, you kill one so 3 can survive. That's kind of the questions that are posed in this case, and I just think it's really interesting. And I remember we had a whole discussion about it in philosophy of law, and it was quite like a heated one, because there's so many different points you can look at this case from, that it's quite rich, the judgment is. And finally, for criminal law, now this case, oh my gosh. So this case, I did my first year of law school. I did this in a module called Introduction to Law and Society, which basically just looked at issues the law and legal sector was facing. And I think I did this within my first week or two of university. I remember being very early on, and everyone was so shocked by it because the contents of the case is bit raunchy, basically. And it's a case that once you do it at law school, because the subject matter is so rogue and so different, it just sticks with you for life, and you can only mention the case name to any law student and they'll be like, I can tell exactly what happened in that case. And that case is R. and Brown. So this case is a relatively recent case, for considering all the ones I've mentioned have been like really old. So this happened in 1993. Basically, let me just read the facts out. There's no way I can like preface this case, so let's jump right into it. So the facts. So you have 5 appellants, defendants, and basically they engaged in sadomasochistic sexual acts to which they consented to in order to get sexual gratification. And in the case, they say, you know, all the stuff that they do. And we're not talking about a bit of bondage, a bit of whips. We're talking about they nailed their penises to the floor. They like branded each other. It was some like hardcore shit, okay? And what they did is they videoed them doing these acts, and it was all consensual. They videoed themselves doing it, and the videos were uncovered during a completely irrelevant police investigation. And from the uncovering of these videos, the police then just prosecuted these people for what they were doing in their downtime. It went all the way up to the House of Lords, which at the time was like the Supreme Court, the highest court in England, because in the lower courts, the trial judge had said that you can't consent to that level of bodily harm. Like, if it's truly gonna hurt you, you just can't consent to it. They basically then appealed that kind of line of decision making. So in the final ratio of the House of Lords, it was a split decision of 3-2. So, you know, it's quite contentious because it is kind of quite split. They decided in favour of the previous decision that said that the consensual infliction of harm on another person for sexual gratification was not an act that the law could permit. So the law just would not allow 2 people in their private abodes in their downtime to consent to harms on each other for, you know, sexual pleasure. And honestly, the principles in this case and the ratio generally has received a lot of criticism. I wrote an essay on this, I think in my second year, and I basically tore it to shreds, saying that it's kind of outrageous, to be honest. And essentially, the main criticisms around this case are centered around the fact that the defendants, the appellants in this case, were all homosexual males, and it was thought that the decision was decided in this way out of homophobia rather than out of objective decision making from a judge. And this is thought to be the case because a few years later there was a case called R. and Wilson in 1997, and that involved a husband branding his wife's arse, basically. That was found to be fully consensual and legal. So they often compare the two because the acts in both cases were very similar, but one involved a heterosexual couple and one involved homosexual males, and the homosexual males were found to be, they can't consent to that level of harm and it is illegal, but the heterosexual couple, oh no, that's fine. So in my opinion, this case is like laced with homophobia, especially if you read some of the comments that are actually in the judgment, and it's quite a really brutal and blatant example of discrimination and homophobia at the highest level in law, and it's seen in quite a few cases that are subsequent from that, especially cases that involve sort of like sexual behaviours. So it's just an interesting case generally, and also the facts are just a bit more wild than like other cases, so they really do stick with you. So that is the end of the cases that I wanted to go through, the top 5 cases that every law student, every person should know. Gives you a bit of a taste of law, and hopefully you find it interesting. I will put the links to all of the cases below if you want to read the full thing, and also timestamps for when I'm talking about each case. If you want me to do another one of these, or to do a similar video, or go into law a bit more sort of formally, and I always feel like this is a bit of a lecture, I don't know, then let me know. And I really liked making this video and researching cases that I honestly haven't done in about 3 years, so it's interesting for me to like recap on all my notes. But yeah, let me know if you want similar content to this. I'll be happy to make it, and in the meantime I will see you in the next video. I'll see you next week. Bye guys.